Today, I will present you the result of a project that has been undertaken between 2018 and 2019. I'm here with my colleague Tine van Hoff, but also other colleagues that participated in this project are present, and I would like to thank them all. And I will also present a new project that has been undertaken by the University of Genoa recently and between 2020 and 2021. And some of our amazing colleagues in this project are online too, I think. I saw them. First of all, the two projects are named the Voice Project and the MIRI project. Those are the acronyms. And we will start with the results of the concluded Voice project that was focused on the best interest of the child in international child abduction proceedings. Within the Voice project, we conducted between the universities of Genoa and Antwerp, with the collaboration of external experts, a legal research and about how judges give substance to the best interests of the child in proceedings. And there was also a very interesting part in this regard concerning the hearing of the child by the judge. And the All Voice projects indeed comprehends also a sociological research on family resilience and trainings on child inclusive mediation. But if you want some more information about those parts, the materials can be found to the project's website. And as concerns the legal analysis, our team looked into accessible case law on international child abduction in Europe with the help of our external experts, and the scope was to find out whether and how judges give substance to the notion of the best interest of the child. The research covered all the cases, all the viable cases between the entry into force of the regulation Brussels IIter in 2005 until December 2017. The project started on January 2018. And with the help of country experts, we could cover 70 national jurisdictions. We gathered 938 national cases, and also case law from the European Court of Human Rights and the European Court of Justice have been included. And we analyzed all those decisions through Qualtrics and Vivo, which are tools for qualitative and quantitative research. And the first part of the analysis, as I said, focused on whether and how judges give substance to the principle of the best interest of the child. And the research indeed confirmed that the principle of the child's best interest is indeed acquiring importance in international child abduction proceedings in Europe, because judges mention the child's best interest within their case law, their decisions. And as you can see, we found out and we divided the decision according to the fact that they gave an explicit reference to the child's best interest in those exact words. And other decision, on the other hand, made implicit reference to the best interest of the child without naming it in its exact terms. And the principle is indeed acquiring importance, but there are also many decisions that did not mention the principle of the child's best interest in child abduction cases, indeed, nor explicitly nor implicitly. And another data that I will share with you today is that judges does not seem to refer to consolidated pattern as concern the child's best interest. There are many and different heterogeneous factors that judges refer to in order to give substance to this principle. And so the elements to consider were very many. And we were indeed able to find some recurrent patterns in this regard. The first interesting, very important data is that in many cases, 182 cases out of 309, the courts made explicit reference to the child's best interest and connected this principle with the rationale of the Hague Convention of 1980. The Hague Convention is therefore assumed as a legal basis for the principle, And the principle of the child's best interest is considered fully integrated with the Convention in many cases. The rationale of the A Convention says, as we know, that the best interest of the child coincides with his or her immediate return to the state of habitual residence, unless some of the exceptions apply. And in all those decisions, it was found out that for the judges, the Hague Convention fully pursues the best interest of the child with this exact mechanism. So a correct application of the Convention is considered in line with respect to the best interest of the child. And another data that emerged as a recurrent pattern is that judges often made a reference to the principle of the child's best interest in connection with the jurisdiction consideration. Because in many decisions, judges have stated that the Court of Habitual Residence is the best authority to evaluate which is the best interest of the child. So the return of the child is in the child's best interest, not only for substantial reasons, namely the return to the habitual residence, to his social, familiar, affective, or cultural environment, but also because for procedural reasons, it enables the competent court to decide on the merits. Another pattern that emerged is that many judges connected the best interest of the child with its living conditions, or the living condition that he or she faces both in the country of origin, the former country of habitual residence, and in the country of refugees. And in general, we saw that the bad living conditions in the state of origin may justify the non-return of the child, but we need a high standard of danger here in order to apply the exception of Article 13, letter B of the Convention. So this is necessary to ascertain, according to the judge, the existence of conditions that are incompatible with acceptable social, economic, and psychological standards in the state of habitual residence. And on the other hand, the mere existence of welfare, better conditions in the state of refugee compared with the situation of with the state of habitual residence do not justify per se the no-return of the child. We need something more here in order to correctly apply the exception to the return principle. And those that I said are the most recurrent patterns in the decisions that we examined. Other relevant interpretation of the principle of the child's best interest are the following. Those are some elements that we found out to be recurring in the decision, although not as often as the others. But for instance, a very important factor that is considered by a lot of judges is that the best interest of the child coincides with the possibility to maintain a stable relationship with both parents. So this can be a key for the interpretation of the Convention and foremost for the application of the Convention's mechanism. And of course, the situation here is a little bit more complicated when one parent results to be the primary caregiver of the child, especially if the child is very young. In this case, the court has stressed the necessity to not separate the child from the parents who take full responsibility of him or her. And lastly, two other important factors were the need for the courts to find a resolution of the conflict between the parents in order to foster the child's best interest and the well-being. So parents have been encouraged several times to cooperate or go to mediation in order to solve the conflict in a less stressful way. And also some courts have stressed the importance of an adequate preparation of the child in case of a return decision. Parents or other subjects involved may need to prepare the child and explain to the child the reason for the return in order to avoid the inevitable mental stress associated with the enforcement of a return order, of course. Then the second part of our research focused on the hearing of the child. Here, we were interested in understanding which is the role of the hearing of the child when the courts are assessing his or her best interests. For this reason, we examined only the decisions that took into consideration, either explicitly or implicitly, the best interest of the child. On those decisions, we examined whether the judges heard or not the child, and which was the impact of the hearing on those decisions. It is interesting here that we found out that the courts use and give consideration to the views of the child, not only to apply the exception of Article 13 2 of the Hague Convention, the objection of the child, but the hearing here had an important impact also in order to assess the application of other grounds of no return. So hearing can be effectively a tool to offer broader insights on what's in the best interest of the child in general. So here we made a short summary on what happens when the child is heard, because the child's view could influence the final decision in several ways. In some cases, the child's views were decisive for the purposes of the final decision. And here again, this was not only linked to Article 13.2, but also to apply other grounds of no return. In other cases, the child's views were decisive, but other factors were considered, or the child's views were considered equally with other factors, or not even taken into account. So here there is a very broad spectrum of on the weight of the child's hearing in front of the courts. The results are used in very different ways. And again, we also examine what were the reasons for not hearing the child. When the child was not heard, a lot of courts made a reference, in most of the cases, to the age and maturity of the child. And in several cases, also the court seemed to go also beyond the condition of capable of expressing his or her own views, that is, the conditions stated by the Article 12 of the United Nations Convention on the Rights of the Child. And also other factors have been brought by the courts in order not to hear the child. So also here the range of justifications was very broad. So in conclusion, the voice research has shown, first of all, that the principle of the child's best interest is rich in contents and meanings in the EU case law, because courts refer to heterogeneous and different factors. The analysis enabled to find some recurring patterns, and we saw that this interpretation usually play a role in the way the judges interpret and decide to apply the grounds of no return of the Hague Convention. And also in the cases in which the child was heard, we saw that the courts took into account the child's views in order to effectively assess the best interest of the child and to refer to the application of the Hague Convention in general, not only for the purposes of the child's objection as a ground for non-return. So those are the main findings of the VOICE project. I will proceed briefly to explain the content of the mirroring project, which is ongoing. We are also finishing the first year of this project. So here the scope of the investigation is a little bit more precise, because the investigation we did in the mirroring project consists in a legal research on children's right to information in EU civil proceedings. The research covers 6 EU countries in which we are doing a national analysis, and we are also analyzing for these purposes the role of social services in Italy. And here we would like to examine whether in the application of the EU instruments in the field of family law and civil cooperation in civil matters, how is fulfilled by the national legal systems. And the final scope of the research is to formulate a set of guidelines of common best practices that can be applied by practitioners at the EU level. And briefly, I think I still have some time to explain. 2 minutes, okay, great. The child fundamental rights to participate, we know, is consecrated by human rights law. But the premises of the research is that the child's fundamental right to participate and express his or her views cannot be effectively exercised if the child does not receive adequate knowledge and support. Those have been already expressed by human rights law. And therefore, there may be a need to bridge a gap between human rights and the EU regulation in this regard, because those regulations promote and sometimes introduce relevant procedural changes that impact upon children involved in family proceedings. But however, the same instruments do not always impose any change to domestic child consultation procedures. The result is that significant divergence exists between member states in proceedings for giving adequate information to the child. And here we have some interesting insights from the Italian research report that we are still doing, but it's almost finished, about on many aspects in which there is a lack of fulfilling this right to information. So we hope that in general this research may have a strong implication on the application of the EU instruments in the field of judicial cooperation in civil matters and on the right of the child to information, also to influence the correct implementation of the child's best interest. And of course, many questions and research issues may be raised in this regard, but we will do that. So I thank you for your attention, and I think that's all from my side.